Hi, everyone. Welcome. Thank you so much for joining us today for the ninth and final session of our Franzic PC 2020 Virtual School Law Conference. I'm Jackie Godapur-Werns, and I'm excited to welcome you today. For those of you who've been with us since October, when we began this virtual school law conference, you know that each year we have an annual conference for school law clients and friends. We're always so excited to be in Oak Brook with hundreds of you for sessions on all the school law topics on our minds for the year. This year, obviously, with COVID, we were not able to all be together in person. And we also had become accustomed to all being together virtually at noon on Thursdays for our COVID webinars. Way back on March 30th, 2020, which is sort of hard to believe, our Franzic PC school law team, and particularly the ladies you see in front of you right now, began bringing you a fast-paced panel discussion of the most pressing questions facing Illinois schools as they respond to COVID-19. Between March 30th and the end of September, we brought you 28 COVID webinars. So we decided to use our Thursday noon COVID webinar time slot to bring you the sessions we would otherwise present at our school law conference. Our conference was on Thursdays at noon between October 1st and December 3rd with a break for Thanksgiving. If you by chance missed any of our sessions, don't worry. You can find them all on our website at franzic.com under events or on our YouTube channel. We are ending where we began with our school law conference with an update on COVID-19 and schools. I am very excited to welcome the panel you've come to know and trust, our COVID-19 crew, Shelley Anderson.
Hi, everyone.
Nikki Baser.
Hi, everyone.
Dana Fattori-Crumley.
Good afternoon.
And Jennifer Smith.
Hello.
Before we begin, as we promised, we will turn back to our COVID-19 webinars on Thursdays at noon now that the school law conference has come to an end, although we will continue to sprinkle in other topics as warranted. So for instance, next week, we will be back with our COVID-19 update with an Ask Anything. So please make sure to send us your questions through the registration process or to covid@franzic.com. Then please mark your calendars for December 17th for a webinar addressing changes to the fields of labor, employment, and education law based on the recent presidential election. Please make sure to watch your email for registration details for our upcoming webinars. And as always, please submit your questions today using the Q&A function in Zoom, and we will do our best to answer them. All right, let's jump right in. It has been 2 months since we last came together for our COVID roundtable. And when we picked the title way back then for our first school law, for our final school law conference session, we picked, Are We There Yet? And I think we were hoping that maybe this difficult situation would be behind us by now. Unfortunately, we don't seem to be anywhere close to there yet. So why don't we start out by going around the table to talk about what are we discussing today? What are we thinking about today that might not have been something we were talking about 2 months ago or that's changed in the COVID landscape since then? So Jennifer, let's start with you.
Sure. Well, the thing that came to my mind was testing, and especially mandatory testing for students and staff. So that's something that's really started to pick up speed as these things are becoming available for school districts. We're having clients pretty far along in implementing different testing, different uses of testing. And it really is a little bit all over the map. But where we get some particular legal stickiness or issues is around mandatory testing. When we get the question, what if we want to require tests for students to attend in person or for staff? And I guess just to kick us off, I would say this is one of those issues where you're making the decision to accept some risk. And so it's really, we'll talk about it in this setting and definitely give our thoughts, but this is the kind of thing where we really would want to advise a school board and the decision makers about the risks and make sure that we communicated that in an attorney-client privilege setting so that there's a complete understanding of what decisions it is you're making and what risks you're taking on. And I feel like, unfortunately, there's been so many of those issues. I think the weight of all these different decisions, this is another one where, well, the law's not clear. It's this on this side. It's this on this side. You kind of have to make a decision and live with it, and it might go wrong either way. This is definitely in that category. So I know some of us can talk about the different pieces we've been looking at. I mean, big picture, we think it's possible. We think there's legal authority for it, but there are risks. And I guess the one that I think is kind of, in a way, I don't know, most obvious is if one were to look at the CDC guidance, they say it is illegal and unethical to mandate testing. So certainly we've gotten some, well, I saw that, is this even possible? We disagree, I guess, is the bottom line with, we don't know the basis of that guidance. It's just guidance, and we think it's outside the scope of the CDC. CDC is not going to be knocking on your door enforcing anything on this topic, we believe. So, but that just shows the complications. Ladies, I know that there's a lot of different pieces. You want to weigh in on this one?
So, one of the newer tests that we've talking about screening tests, and there are different types of tests, and Jennifer alluded to this, and I know Nikki, you've been working on this exclusively, but some of our districts through their county departments of public health have been offered BINAX testing, which is not a screening test, but an actual diagnostic test. It's a rapid test. Nurses can be trained to do it, but there's a very specific protocol that you have to follow in order to administer the test. And again, the issue is, can you make it mandatory? Right now, we're having clients use it not in a mandatory way, but if you are hearing this from your Department of Public Health, we recommend you reach out. We can guide you through what you need to set that up in your school district, because it can make a difference in terms of knowing right away that you have a positive test and quarantining in a limited way. And also, of course, making staff feel more comfortable, which Shelley is an expert on the topic.
Yeah, well, I was going to add here about the mandatory testing piece, Jen, is, obviously you have a bigger sense from the student perspective, but just from the staff perspective, I know those districts that we work with that are either doing the screening or the diagnostic testing, because we certainly have both, are dealing with it with respect to mostly on a voluntary basis and have gotten a lot of really, great participation. But when we're looking at wanting to even increase the number of kids in school, for instance, which may then mean that 6 feet cannot necessarily be maintained as much as it otherwise would be with respect to social distancing. How are they going to mandate that to make sure that everyone in the building is getting tested? And one thing that we just want to remember is that it's certainly our position that you can do it. You do need to notify the unions that is going to be your intent, and then bargain the impact of that with them. And I think that there's a number of different pieces to that you're likely to see if you want to go in that direction. But as Dana just mentioned, part of this we have seen is a way to make teachers feel safer about being in the buildings, which could then obviously reduce staffing issues and allow you to get more kids in the building more long term. So I think that's what I'm primarily seeing there.
And I mean, what I've heard is that some of that surveillance testing really depends on a very high level of participation. And so I think that's where you get the discussion about, it may not be good. It depends what purpose you're using the testing for, but that's why it may not be good enough to get voluntary if you really need almost universal participation. And yeah, so on the employee side, it's you can, but on the student side, it's also you can, but, and on both sides. So some of the caveats are religious exemptions and also procedures for a due process. So ultimately, we may be, if you require it, you may be then excluding students from attending school based on it. Now, you might be sending them to remote, and so that's a little bit different than just not educating them. But at a minimum, we think there has to be a process. And if you're sued, you have to show some due process in the exclusion process. We don't, it may not need to look like a full-blown expulsion hearing. but it needs to be something to establish due process. So these are, I mean, this is to take us back, Jackie, to what you were saying, this is a step forward or a different intervention, safety protocol that we weren't talking about this summer that is now available. It's another tool in the toolkit. It's not like Shelley said, maybe you can get, it's one of your options to get people back in because they're going to feel safer, but it's not the end all be all. We still have to do everything else. And I guess that's critical to know. This doesn't replace, it's not like you test and then you don't have to do all the other stuff. This is one more thing that you might do.
That's a great point. Dana, we know there have been recent changes from the CDC relating to quarantine requirements. Can you talk about what is the change and what is the impact for us?
Sure. If anyone receives Education Week, their briefings daily, this was one of the headlines today in their daily email. This came out this week from the CDC, shortening the quarantine requirements and making them a little bit more manageable. It's not like they're radically different, but the two new requirements are shortening the 14-day quarantine to a 10-day quarantine. So if you are if you're exposed and you're monitoring symptoms daily and you have no symptoms in 10 days, that you can end the quarantine at that end of that 10-day period. And if there's testing involved, so if there are resources available, the CDC makes it very clear that there should be resources available. If you have access to testing and it's diagnostic testing, that I'm going to get the initials wrong, if someone can help me, PRCT, I believe it is, or I'm close. Everyone knows what I'm talking about, I think. Then the quarantine can end at day 7 if you get a negative test result from that type of diagnostic lab test. And you would have to get the test within 48 hours of the 7th day. So testing between days 5 and 7, it comes back negative, you can end your quarantine then. Now, IDPH has not updated this yet on its website, but we expect that they likely will. Education Week talked about that just having this sort of shortened period is going to help kids get back in school quicker, because now we're talking just 4 fewer days, quarantine shorter for staff too, especially when people aren't sick. That's going to relieve some of that people being out for a long amount of time.
So I was thinking now we just go around and sort of pick your brains about what you see as the most pressing issues right now that we haven't already talked about. So Shelley, why don't we start with you? What do you see as the most pressing issue right now in the COVID school landscape?
I think certainly in my practice, Jackie, the most pressing issue that I'm seeing continues to be staffing issues. And that's especially so when districts are moving from remote to hybrid, or now that so many are going to an adaptive pause, and how to handle the number of staffing issues that arises from that. So I'm just to talk about a few of them. This idea of, if someone has an ADA accommodation, that might allow them to, or they might be asking to work from home. And if you're in a remote environment, it might be a lot easier for districts to say, okay, this group of teachers who are asking to work from home can do so, even if we're expecting the rest to still teach from the building with kids learning remotely. However, when you go back and you are in a hybrid environment, how do you handle that? Districts across the state that we work with have handled this very differently. So we have some districts that are doing whatever they can to get kids back in the building, even if that means having a non-licensed teacher in the classroom, turning on the screen and doing the supervision of kids, and having the teacher teach remotely from home, where other districts are saying definitively, we do not have remote teaching positions. Therefore, if you cannot come to school and teach from the classroom while kids are there, we have to talk about some sort of leave that you're going to take. Now, when you're jumping back and forth from a hybrid to a remote or hybrid to an adaptive pause, you really have to start looking at those individuals again. Are those people who you said could not work, are they now able to do it from a remote place? And so, for instance, those people who are on FMLA leave in particular, so these are the individuals who have said, look, as long as we're in hybrid, I need to be on this leave. presumably they likely can do their job when you're remote, and you can't force someone to stay on FMLA leave. So for those days that you're in that environment, they would not have FMLA leave charged against them. You know, we've tried to get creative and remember that, you know, we're all trying to do what's best for kids here. So not have teachers jumping back and forth out of the classroom. So either that teacher becomes a co-teacher to the teacher that the kids have already been working with in the hybrid environment, or perhaps you have that teacher do other sort of certificated work during that time period so that they're doing something that's a benefit to the district and not losing their time. So we've certainly been working with a number of districts on that. The other piece here is, you know, when we talk about where we're at now, I think everyone's aware that the FFCRA is going to expire, or set to expire December 31st. And for many of our districts, though, we have already had teachers who've used it up. So they've exhausted that child care leave in particular is what I'm talking about. So what happens then, and what options does the district have when you get to the point where either they haven't used it and it's now not available, or a teacher has used it up, or a staff member who's used it up, and really working with the districts on what their options are there. So I mean, the obvious option is that you could have the person take unpaid leave of absence. But I would, you know, remind everyone to check your agreements because that could relate to bargaining. I have a number of districts I work with that the unpaid leave of absence portion of the contract, for instance, is just for tenured teachers. So making sure that you're entering into an MOU that indicates that that is also applying to probationary teachers if you chose that route. Another option is to allow that individual to then work from home if they are still having childcare issues. And then the extreme side of that is obviously to say you either have to be able to come back to work and figure out childcare at home, or you have to resign. And I do have a few districts who are taking that approach for a variety of reasons. I want to just mention one piece here, and I know that, you know, all the HR folks listening are going to bristle when I say this, but if you are in a position where you are now looking at your individuals who are on FFCRA, childcare leave, and it is expiring, to allow them to work from home, make sure you go back and look at all those individuals who denied the ability to work from home based on a disability, if that was the position the district was taking, because you don't want to say that this group of teachers who don't have a disability but childcare issues can work from home, but this other group cannot, because it is likely going to lead to an ADA claim. So you really have to continue to monitor. It's going to be a process. So I know all the HR people I work with have not stopped being busy at any point during this pandemic, and I'm sure all the other administrators have not, but this is really just a cycle that we're going to likely see through the end of the school year. So that's kind of everything that's on my plate with respect to those daily issues.
Shelley, do you have a sense of, you set several different options with the FFRA expiring. Do you have a sense of what is the main approach that we're seeing are most doing the unpaid leave, are most doing the you need to come back or resign? Do you have a sense of it?
Well, I would say from the districts that I work with, the majority are first and foremost trying to work with those teachers to figure out, are you sure there's no other childcare available for you? I mean, a few districts we work with have what we'll call, and they do call the Zoom room, which means that those teachers can bring their kids in to learn remotely, but from the school building, which would then allow for the teacher to come to school. So I would say that from the overall districts I work with, trying to work with those teachers to see, is there any way that you can come back? And if not, I would say primarily, I would see the unpaid leave option as being a primary avenue, and then less so the districts who are allowing them to work from home. That I think has been the biggest point of contention. I mean, there are, rightfully so, you know, school boards who feel very strongly, if you have to be home taking care of your child, what instruction are you able to provide during the school day as you should be during your job, and having concerns about that. And so I think that some districts are doing that because they do want the teacher still in front of the kids and not having a sub in the classroom. So I would say that the least approach, the approach I'm seeing the least is this idea of you have to either come back or you have to resign. I know there are a variety of reasons that districts might be moving in that direction. And you have to remember, we're not just talking about teachers, and this applies to support staff employees as well. And, you know, I will remind you, it is okay to treat those groups differently. You do not have to necessarily treat them the same. And certainly the benefits that are in their agreements likely support treating them differently if that's the approach the district wants to take.
Mm-hmm.
All right, Nikki, I was going to ask you next. What is the most pressing issue that you're thinking about or seeing now?
I feel like I should talk really quickly in case like my entire computer just crashes again. So I apologize for that. One of the things that we've been thinking about a lot and seeing is the discussions now about vaccinations. Can we mandate vaccines for staff once the vaccines are out? Can we mandate them for students? I think there are a lot of open questions, and frankly, we are working through those questions right now, and I think we're going to have answers, at least our answers, as relatively quickly as we can. I mean, I think that there are, bargaining implications certainly, and labor implications to mandating testing for staff. For students, I think it's obviously we have school code provisions that allow us to mandate certain vaccines. So the question is, do we have powers outside of those to mandate vaccines that are not specified by the Department of Public Health? Or if a vaccine comes out, will ISB and IDPH be working to amend regulations or to mandate testing? I saw one of the questions in the chat or the Q&A that came in was about, is ISB essentially going to give us some useful guidance? And we're going to talk a little bit about some guidance that ISB recently put out, and I understand the frustration. And one of the areas I think where some clear either mandates, or guidance, but mandates even better, would be around these issues of vaccines, because again, we're going to dive into the legal issues. If folks are starting to get those questions and want answers, please come to us. We should have some thoughts on it very soon. But certainly state mandate or guidance is an area I think that would be quite welcome at this point. I know that we're still waiting for those vaccines, but I know school districts want to start planning and understanding these answers now, so that we're not continuously sort of running behind the 8 ball like I feel like we have been up to now. So again, more on that soon, and maybe even by next week when we have our Q&A Ask Anything session.
Well, and I did see a question in the Q&A when these are somewhat related topics, the testing that I talked about and then the vaccinations, were at least in the same world of law, the same statutes, same principles. Someone asked if when I said you still have to do everything else, am I talking about PPE, social distancing? Yes, that's what I was referring to. All of those, IDPH guidance as far as what are the safety precautions still apply whether or not you do testing. Now, that's a kind of an interesting question once we get into vaccinations. Is there going to be a point where if you're vaccinated, you don't have to do that? I think that's a pretty open question, and, we're still learning about the science and whether if you're vaccinated, you can't spread it. So I think these are the types of issues that will be rolling this spring that we'll really need more guidance on.
Yeah, I think that's a great point, Jen, because what I've seen, and again, we're getting news as you guys are from the news media and from various state officials and federal officials. But my understanding is that we may not see approval for children getting vaccines until after we see approval for adults. And I know that's been sort of a moving target. And so what happens if we're vaccinating adults? What are the precautions that we use if students haven't been vaccinated? And all of those questions sort of tumble from there. So I think, again, these are the right questions, and we'll, hopefully get some guidance and answers out to everybody. I think on the testing front, we've got a lot of good resources. I know I was sort of in and out. I know Dana was talking about the Binex testing, very technical stuff. We've got a lot of really technical documents if people need them. And I think we're going to see the same on the vaccination front as people try to figure out how to navigate through those issues.
All right, Dana, your turn. What are you thinking about seeing? What's most pressing for you right now?
So I think on the special ed front, just to sort of raise that topic for everybody, we're seeing now that we've had districts go back to school for sometimes an amount of time, or had special ed kids back, we're seeing an uptick in complaints. And I do think that you would think the opposite would be true. Like, we've gotten more kids in, why are we getting complaints? And I think it is this, what we've heard about in the media, the COVID fatigue, and just having parents be home with special ed kids all the time. and sort of understanding what it is that you do every day to make sure that their children are learning, and now having to cope with that sort of without the support of school is causing an uptick in complaints. And we actually had one question in the chat about, have we seen an uptick regarding students staying past 22? And I think we have seen some complaints in that area. And I think it really depends. Again, there's been no cases out there that say you miss 2 months because of remote and you get 2 months at the end. It's still the same legal analysis for determining what if any compensatory relief there would be. So we see more complaints. We see parents saying, remote is a placement, and Jen, we know remote right now is not a placement, right?
That's right. Yeah, you still look at their access to gen ed peers, their amount. Really, it's who's instructing them. Are they being instructed by a special education teacher with just, other students with IEPs, or are they being instructed by a general education teacher, and they're, so that's really the placement, not is it on a screen or in person. That is, I would call it a modality, and not an IEP decision. And I've continued to maintain that to the extent there's been disputes, that this is not even something that a hearing officer should get to decide. Now, what they will decide is whether you implement what's in the IEP. So if there's, speech, social work, whatever, you can't say, and this is where I think it gets hard with going back and forth. Well, our schedule changed, so we haven't been doing the related services because it just didn't fit in the schedule, or we reduced the minutes of the special education instruction because we have this, we changed. I think those things, that's where you get trapped a little bit, because now you're not implementing the IEP, or if you did an amendment, now the times are different because it's different on the pause. These are the things where I think you can get dinged. You mentioned the transition. I think both of us have taken a kind of practical view of some of those cases where most situations I'm trying to really push off that compensatory education or services discussion, because I don't really even think it's meaningful right now. I mean, there's no extra time, there's no extra place, there's no in-person extra that's available right now. So it's kind of a pointless conversation. But if someone were to age out now, I think both of us have done agreements. Someone's aging out, they just really want remote instruction for the rest of the year. It doesn't affect your staffing, so it's kind of a win-win. You don't mind if they stay in. I mean, normally they would age out, but that's sort of a easy agreement to reach, is you waive your claims related to COVID, any denial of faith during this whole period, and you can just stay in the program for the rest of the school year. I don't think that seems to me a practical thing when you're looking at transition students.
Great. So Shelley, you touched a little bit on labor, but tell us, what are you seeing on the labor front right now?
Well, I'm going to hope you can hear me better. Is that better? Yes.
Yeah.
Okay. So I've got headsets and that works better. In terms of labor, I did mention it a little bit earlier. I mean, I think that one thing that our clients and all school districts have to realize is this idea of impact bargaining really is going to likely continue every time there's a change that's made, and every time we go in one direction or another. It's not as if all the decisions we made perhaps at the beginning of the school year that the union was able to say, yeah, I know that's going to impact us, so we're going to meet together to do that. So, not only would mandatory testing be one or vaccines be another, but even we are seeing a lot of unions come forward now with respect to the decision of a school district to, for instance, move in a direction toward having more kids come back to in-person instruction. Now, it is certainly our position that the decision to do that by the board is not something you need to bargain with the union, but that the impact of that is something you need to bargain. So for instance, if they're not feeling like there's enough safety provisions or the PPE is not appropriate, I mean, things like that, to say, this is what we feel should be, how it should be handled. We do, however, get pushback from the unions, because certainly they're taking the perspective that that decision in and of itself is something that they should be able to weigh in on and bargain. So certainly seeing some grievances being filed as of late related to the idea of requiring teachers to come back to school with kids is an unsafe working condition. So for those contracts that have provisions in it, they are claiming have been violated by having teachers come back. I've seen that in a few places. And then with respect to the accommodation issue, in a number of districts, we've been seeing unions getting very involved in how our administrators are determining who gets an accommodation, what accommodations are being given, how we're handling it. And I would say, you know, filing very extensive requests for information as to the specifics of that. Now, I will say, you know, the ILRB defines what scope of information the union's entitled to very broadly. I mean, it's anything that can impact their ability to represent the members and their terms and conditions of employment. That being said, though, we do have an objection if it's confidential information or if it's information that we otherwise are able to say, this has nothing to do with your management of the contract. It may arguably have something to do with the term and condition, but when we're talking about the ADA, when we're talking about leaves typically outside of what's in the contract, those are statutory. And at the end of the day, if someone wanted to object to how the district handled it, there's an avenue for the employee to go forward and make that objection, not for the union to go forward and make that objection on their behalf. So, you know, I think, look, I've said it for the last, you know, over 30 weeks now. Collaboration is key. It's the way we're going to get this done. We all have to try to work together. And I think this is just another area where really being able to sit down with the union and say, you know, what actually is your concern, and trying to come to a understanding about the decisions the districts are making in that regard. Hopefully we'll get you kind of past that hump of having to do a lot of work that you shouldn't otherwise have to do to kind of put that information together. So that's kind of, I think the bargaining, the grievances, and the request for information is really kind of what I've been working on a lot as of late.
Shelley, I don't know if you're feeling it, but it feels to me, and the clients that I'm working with on some of those same issues, there seems to be a shift where at the beginning of the school year, maybe there was more sympathy about, I guess, the safety concerns. I think there's a little bit of a weariness, or people are getting a little worn down. We're certainly seeing, I mean, we see on the news some protests by parents. You know, we're getting more pushback, I would say, on the community side, on the management side. Why, you know, anyways, I just wondered, you said collaboration continues to be key, but do you feel that tension, and what do you see as the best way to work through some of that? Because I think there's things that people were, maybe boards were more willing to, you know, like be accommodating, not in the ADA sense, but just broadly accommodating, you know, of teachers' concerns. And now I see that wearing pretty thin at this point.
Yeah, I would agree with you. And I think part of the reason for that is, one, to the extent that some schools have testing, they're able to say, look, this is not an unsafe environment, and we can actually show you that the kids here who've been tested are not positive, nor are the staff. And I think also when we look at experience in schools that have been open and the little spread that has actually been documented to have occurred in the school itself. And then I think a lot of schools are also looking at their local metrics. I mean, I know that, you know, the state had to find a way to break us into regions to assess this kind of from a bigger picture perspective, but that's not necessarily informative of what's happening in your particular district. And so we look at it that way, and then we look at, the one consistent thing that I think we hear from everyone is everyone agrees it'd be best for kids to be back in school, and that should be the goal. That being said, we are seeing, you know, some pushback still from unions about, as I was mentioning, the grievances and pushing back about inviting more kids into school or going back to a more in-person instruction, especially as of late when we're kind of in this tier 3 mitigation stage. But those community groups pushing back, that I think, when I was mentioning collaboration before, I certainly meant with the unions and the management, but I think it's even with those parent groups. I think there is a lack of education by our parent community who so rightfully so want their kids back in school, but not understanding why the decision is being made perhaps to not do so. And I think it's a really easy out to say, you're bending to the unions, they're the ones forcing this issue. And perhaps it is true in some schools, but it's not universally so. And there are also, you know, very good reasons why boards and superintendents are having to make the decision to take an adaptive pause here or make a decision to do remote here, and having that collaboration and communication as to why that decision is being made, I have found has been really helpful with those parent groups, because you're right, they're everywhere. They're in the schools that haven't been back at all, they're in the schools that have been back a little bit and they want more. So I think that just making sure you can be communicating as much as you can with your community is going to serve everyone well.
Right. And Shelly, one of the things that when you were talking, I thought of is just, a lot of the times the reason that people have to do an adaptive pause, it's not so much that the numbers are so high, it's just that we don't have staff, right? There's so many practical concerns. I mean, people just sort of think that their kids go to school and they're taken care of, but you need adults in the building to run a school. And I don't think parents always understand that.
I think that comes from a few things, Dana. I mean, I think there's this idea that, we just have this, group of teachers out there who are willing to come in and they be able to do that, who are unemployed right now. And there isn't. There's a teacher shortage in the state, and there's also a sub shortage. So even getting a sub in. And I talked to a district as recently as yesterday who said they were willing to allow some more teachers to work from home, but they cannot find anyone to come into the building and supervise that class. And that's for a variety of reasons. I mean, and I'm not suggesting at all that it's because it's an unsafe environment, but just the nature of kind of what's happening in the world today, this idea that you would just be able to find someone and address that staffing issue is just not the case. And I think that's another piece that the regular parent out there might not understand, is how difficult that is. And I have other districts where the parents are lining up to say, well, we'll address that because we'll be the ones in there kind of addressing that issue and supervising the class because they so much want their kids back in school. So there are a lot of issues.
All right. Well, Shelley, you mentioned mitigation. So Nikki, what are we hearing from ISB these days about the current executive orders and mitigation orders?
Sure, and I'll ask my fellow panelists to jump in. I think I'm still having internet issues a little bit, but I'll try to get through at least this answer. I do like when it pulls up that it's unstable, because I feel like we all feel a little unstable right now. ISB did just issue some guidance on, we got a lot of questions about particularly whether the mitigation orders, limiting certain numbers of folks, for different activities apply. We got a lot of questions about board meetings in particular, but then ISB did issue some guidance on how they view those mitigation orders applying in various capacities to school districts. I can't say that we completely understand the ISB guidance, but I will try to at least say what they said, which is they do make clear that that the mitigation orders don't apply to board meetings. This was our interpretation as well, sort of, in the sense that the governor also issued a disaster proclamation that runs through December 13th that talked about board meetings and talked specifically about the new statutory Open Meetings Act issues. And what basically the order said was that if a board holds a virtual meeting, it's infeasible. They've made a determination at that point that it is unsafe to hold an in-person meeting. And so you really can't have, if you're going to have people physically located at the meeting as well, even though you're doing the meeting remote, that you can't have more than 10 people. However, there's no prohibition on in-person meetings, and ISB acknowledges that. And once you have an in-person meeting, there's no specific limitation on the number of people that you can have. Again, ISB recommends that you hold remote board meetings. The ISB also said that the mitigation order do not apply to instructional activities. So they don't apply to classroom activities, but they do apply to non-instructional activities like sports and extracurriculars. I think the most confusing section of it, and my colleagues will correct me if I'm interpreting this wrong, is that they said not only do the mitigation orders apply to staff meetings, but it appears to indicate that teacher or staff meetings, you're prohibited from hosting gatherings of any size, which would arguably mean that you couldn't have a staff meeting with appropriately socially distanced staff, under 10 or under 25, depending on the mitigation numbers. This is a little bit confusing to us, but at least that's what ISB has put out thus far. And I think we're gonna, keep probing on that to figure it out. But at this point, it appears that you can hold your in-person board meetings, you can hold your instructional activities, you need to watch the limitations on your extracurriculars, and you have to watch the limitations or possibly not hold in-person staff or teacher meetings.
All right, so Jennifer, wanted to ask you, as many schools are in an adaptive pause stage, what's the impact that we're seeing on remote learning and IEPs?
So I somewhat talked about this when I mentioned, new phase. Perhaps you did remote learning plans at the beginning of the year, and then at some point you went back. It's time to dust those off and see, can we let parents know, hey, the remote learning plan is back in place, or have you changed? I've seen some districts, they're maybe making some tweaks as far as the schedule during the adaptive pause. I mean, the risk is not huge if you're only out for a few weeks. Worst case scenario, Dana said, you're looking at the harm that's caused by the missed minutes. Well, a few missed minutes here and there for a few weeks really is not a huge liability risk in my mind. But if you're missing wholesale services for a month and they're a critical, I guess the worst case scenario is like you're not providing social work or psychological services, and the student really goes off really struggles during the holidays, and we have some major things happen. Well, now you're looking at a substantial change of placement and those kind of things, and you're kind of behind, you're in trouble because those critical services were missed. It won't look like just a few weeks. Our last one that will be on the books will be in mid-November, and now it's January and we haven't done anything. So you kind of have to look at, do we need to update our paperwork? Well, it depends what your pause look like. It depends what your remote learning plan looked like. But that is, I kind of get these I totally get the exhaustion, when I have a conversation, when I'm asked, do we need to update these? It's like, oh, go update these again. That's the last thing we want to do right now. But it's just whenever your paperwork doesn't match what you're doing, that's where your risk is.
Absolutely. And I also think that, even if you do have your paperwork updated, you've got to be really vigilant about kids that aren't responding. I'm starting to see a lot of complaints come in where, kids don't respond. And obviously that's been a major issue in many school districts, even with regular ed kids, but with special ed kids, I think there's a particular danger that if you go a few days and you can't get a kid responding, and then all of a sudden it's a residential placement, because in your mind, well, he could be under the weather, it could be, he has an appointment, it could be whatever. It's not very much missed instruction, especially since maybe you're not having the live instruction quite as frequently. But you've got to be really vigilant, because what's going on when you're not seeing these kids, they might be turning in things, they might be but you actually haven't seen them, you could be at risk for a claim.
Yeah, I mean, I agree, Dana. Those kids that we just kind of have fallen off, and we are getting to a point of exhaustion. So they enrolled, they were engaged a little bit, or maybe they occasionally turn things in, but no one's really seen them for a while, and they're pretty much failing all their classes. I do worry that those things are going to snowball and catch up to us as we turn to second semester. And I think that's really happening a lot of places where you have a high number of failing grades. And for special education, that kind of shows a lot, not always, but that's one indicator of a lack of progress if you have a kid that's failing all his or her classes. So, and I'm hearing a lot of not just failing grades, but zeros, like a lot of zeros. So definitely it's time to regroup on those, and we just want to show we didn't stop trying. We can't just fall off and say, well, haven't heard from them for 3 months, not going to hear from, we got to keep, all right, what else can we do here?
Right, because you will hear, and it will be, we've placed them at the place in Utah, and please pay the bill. That's not the kind of hearing from parents you want to hear.
All right. We are still in a pandemic, obviously. How are we dealing with teacher discipline during this time? Shelley, what do you think?
Started with the conversation. I know there are a few of us on the panel who are still working with this. The one thing I will say is, we are still seeing, you know, issues that come up with misconduct with teachers, whether it's in a hybrid environment or in a remote environment. And I think it's important that administrators stay on top of that and making sure that teachers are taking it as seriously as they should be. And I would say, for the most part, that has been a really positive. But there are, you know, still those teachers, outliers out there who, you know, do need some additional either support or discipline to get them kind of on the right track. And then the piece to me that has been the most, you know, difficult to work through, and it's something I'm actually dealing with this afternoon, is when you're holding a discipline meeting with someone in the pandemic, and it's a credibility issue. You know, do you meet with them in person, which would seem like the best idea, but they're wearing a mask? Or do you meet with them on Zoom where you can actually see their facial expressions, but you don't have as much control over the situation? And I think having to make that determination has been really difficult, especially kind of in cases that we often work on when there is a credibility issue and someone's body language or facial expression is kind of key to determining perhaps if you believe them or what their reaction is to something is really important. So I think that's been a really interesting nuance that I did not anticipate happening with respect to, you know, having to discipline people and have those sorts of meetings with them. Nikki, I don't know what you're seeing on this as well.
Yeah, I would agree. It is really, I think it is difficult. You know, I have had a few meetings and we've done them over Zoom. I do think at this point that's my preference, just because I do think that at least we can see and interact. We've also I've had some situations where I've got attorneys, you know, representing teachers in other parts of the state. They're not wanting to travel and all of those things. And I think ultimately, folks are feeling more comfortable about meeting over Zoom, and that's what we're doing. Again, I think there are pros and cons to both approaches. I guess I land on the side of being able to see people and, you know, create a situation where they feel comfortable from a health perspective being on Zoom, and I feel like then we get sort of clearer and cleaner, you know, answers, and also just, you know, better discussions. So
yeah,
you know, one thing.
I'm sorry, John, go ahead.
Well, just something that bothers me when we do Zoom, if there's two people in the same room, I feel like everyone needs to be on their own computer. I was doing remote testimony yesterday, and the attorney and the witness were sitting next to each other, both with masks on. There was times I thought they were talking to each other. And we really, logistics do matter for these things. And same with if you're just having a meeting, you know, a contentious meeting with an employee or something. So think about, okay, if we're doing it remote, I want to see that person's face. I don't want them like, you know, in an attorney's office with a camera far away where I can barely see. I want each squarely in, you know, in focus where I can see them. I can see their hands even maybe, you know, because anyways, and that preferred to, so anyways, think about those things and work out those logistics, because otherwise you can get really poor testimony and poor interaction.
Yeah, it's definitely difficult if there's more than one person on the screen. I also think that if you really have someone, an opposing counsel, sort of raising a stink about the due process, and you know, you may be in situations, if it's a serious enough situation and you don't want any due process arguments being raised later, you might have to meet in person and use the masks and just do the best you can. It's definitely a brave new world.
So let's jump over to our Q&A. We've got a few questions there that we can get through before we wrap up. So we have a question about lawsuits related to the provision of inadequate services, or in some cases, no services, especially for special education kids, and seeing moratoriums from government agencies on the filing of these lawsuits. How do you see this all playing out? And are we potentially looking at monetary judgments or just the provision of compensatory services? Dana, what do you think?
So, you know, I really have not seen, other than like, you know, lawsuits demanding that kids go back to school, like demanding to open, and those, there's not been regular ed claims of failure to instruct. And I really don't think those are going to go very many places, because ISB has said that remote instruction is instruction. And here's how you do it. Here's how many clock hours there has to be. Here, this is what is synchronous. This is what is asynchronous. So I don't really foresee a lot of claims in that area. I think that the comp ed claims and special ed, we're going to get those, but that doesn't mean that there's not monetary relief there. It's relief in service. And it's not like like I said earlier, it's not like you miss 2 months, you get 2 months. It's really, where are you? And for the kids that are still young, there's plenty of time to catch up, right? I know people are like, oh, it's so awful, and I don't want to discount that, and I don't want to discount people's worries. But at the same time, kids are resilient, and if we put some measures in place when we're all back in person to sort of help people, many of the kids will catch up, and you won't have compensatory ed because you're only in second grade, and until 8th grade, you still have 6 years to go. So
I actually, it's kind of interesting. It's caused us to interact with a different group of parents. And, usually we get kind of more high flyers, who just they're always at battle with their school district. But this, I've had conflicts with parents who maybe usually are not in dispute with their school district. And, I was engaging with this one, trying to resolve one suit, and the guy even said, I don't want compensatory services. He said, I have good insurance. If I need to get private services, I will. I just want you to open the school. All he wanted was in person. So there's like nothing we could give him, but yet he was so reasonable. And, so it's a really different dynamic. Our normal things that we can offer aren't what people want. They only want their kids in school. So it's just a really different time.
Shelley, we had a question about employees and travel. So some employees are traveling to states that require a quarantine period and missing work. While they are on quarantine for elective travel, can we make that time unpaid?
I think there's a few pieces to this question. One, the idea of required quarantine. So I think what they're referring to is the guidance that you should quarantine. So, here in suburban Cook County, we have the guidance that if you leave suburban Cook County, you should be quarantining for 14 days. So whether or not you can actually enforce that, or whether that's practical to do, when we get teachers who live, other places but are then coming to work. Certainly coming to work would be an essential activity they'd still be permitted to do. But when we're talking about more big picture about teachers traveling, so really kind of going to a state that has, I think currently right now there is no list. I think it's determined to be everywhere except Vermont. It's not safe to go to, I think last I looked at that. So the idea being that it's really important that you have a discussion beforehand. So not to throw it at somebody afterward to say, you're now going to have to quarantine and miss work and miss pay because you decided to go to Wisconsin or wherever to travel. So there are a number of different ways a district can handle this. And I think it really does depend on, we have teachers and support staff, one group who has significantly more benefit time than the other typically. And does this individual know that they were going to receive this potential unpaid time off if they went there? Why did they go there? What did they do when they went there? So for instance, we've got teachers who are going to a house in Wisconsin to do exactly what they would do here, being safe, versus someone who's engaging, perhaps here in risky behavior. And we have to decide how we're going to handle that. So I would not say, as a matter of just principle, that I work with any districts that are saying if a teacher travels over the holidays, for instance, that they have to quarantine when they get back. We're really handling on a case-by-case basis and making sure that we're just doing everything we can to be as safe as possible back in that school environment.
So we're just keeping our eye out for that 400-person party in Long Island, right? Okay. All right, let's see. Dana, we have a question. If people wait to be evaluated on day 5 after exposure, the results would not be back for another 5 days or so. Therefore, the isolation would still be over 10 days. So I think this is in respect to the shortened CDC.
And that is a practical fact of probably the guidance. I think their guidance depends on you getting the test back. So you can't get the test. What they're saying clearly is you're exposed, you get the test, 2 days later. That's not going to get you out to the 7 days, because that negative test is not going to be reliable. The test really has to come in that day 5 through 7. Like, it has to be administered and returned day 5 through 7. It can't be administered early in the week, because you may not test positive at that time. So even though it's new guidance, practically based on the return time of testing, it may not shorten the quarantine for the people that do have access significantly.
Makes sense. Yeah, you have to be in a pretty short window there, it sounds like.
Right, and they're contagious.
All right, looking to see maybe we can get one more in here. If a parent has continued outside therapies through a private agency, can they ask the district to pay for those therapies as part of compensatory education? So Jennifer, you mentioned earlier people saying they'd pay for their own. What if they want the district to pay for it?
I mean, can they ask? Yes, they can. Can you say no? Yes. I mean, yes, you can. You know, those are really things that you need to, different districts would handle differently. It depends on, do you think you messed something up for the student or not? I mean, if it's just generally COVID and there's nothing particularly you messed up for a student, I would be cautious to start handing out private services right now. Those are the kind, when I said I'm pushing back on pretty much anything but the aging out student, I would put this in that category where, no, I mean, you can do whatever you want private service wise. We are fully complying. Hopefully you are fully complying with the student's IEP, and we are not in a position to be talking about compensatory services right now.
All right, well, ladies, this was so much fun to be back together again. It'll be great to be together next week for our Ask Anything. For everyone who's listening, please let us know either by submitting your questions through the registration process or by sending us an email to covid@fransic.com. And we will do our best next week to answer all of your questions that may come up between now and then. Until then, thank you, everyone, and take care.
Bye, everyone.